Hello and welcome to today's webinar, GDPR for Comms, Expert Advice to Get It Right. My name is Jake O'Neill. I am a marketing manager here at Vuelio. We want everybody to join the conversation today. We have very many people on the line. It's obviously a hugely popular topic, especially with the GDPR coming into force next month. You can join the conversation on all the usual social channels, on Twitter, at Vuelio, on Facebook you can find us at Vuelio, we're on LinkedIn, we may even be on Google+. You can email us, info@vuelio.com, and you can use the question box on your webinar controls today and ask us questions. There will be a Q&A at the end. I am delighted to say that I am joined today by Rowenna Fielding, the Senior Data Protection Lead at Protecture. Good morning, Rowenna.
Good morning, Jay, and good morning everybody out there.
There are very many people out there. So I am going to take something of a backseat while you talk us through GDPR, and I might chip in because I know we have a number of clients on the line to talk about how Vuelio works with what you're saying.
Sounds great. Let's kick off.
So what is GDPR?
What is GDPR? It is more than just a scary acronym. It's a new version of data protection law that's come out of Europe in the past couple of years. And it's kind of like the Data Protection Act on steroids with teeth. It pretty much takes yesterday's gold standard good practice, which wasn't necessarily the minimum baseline that everybody was following, and turns that into tomorrow's bare legal minimum. So a lot of the stuff is not new, so the principles are very similar, the definitions, the terms and the obligations, but there are some new requirements, most significantly, the requirements to be able to prove, to demonstrate with evidence that you're getting it all right. So this was voted into law 2 years ago, 2016, and then there was a 2-year grace period during which organisations were expected to get themselves up to scratch and into line. And it's enforceable from the 25th of May 2018, which is, I think now something like 29 working days, maybe 30 working days away.
That's pretty close.
So not very long at all. However, it is important to note that this isn't a sprint to a finish line after which everybody collapses. The 25th of May is much more like the due date for an expected baby. The work does not start the work does not stop when the pregnancy ends. The work actually starts there. So while the risk landscape changes a little bit from the 25th of May, everything that people are working towards at the moment needs to be built on and sustained for the rest of all time, pretty much.
Excellent. That's a little bit terrifying, but mostly encouraging that we've still got time to work on this. So what does the GDPR say?
GDPR basically says that everybody has the right to have information about them treated with respect, and so in ways that's fair and is lawful and transparent. So there are some principles for everybody to follow, and this is one of the things that really terrifies people about GDPR, although it actually shouldn't. It's not a checklist. It's not a blueprint or an instruction manual. Principles-based legislation sets out a state of an outcome, a state of being that you want to get to. So, for example, personal data is processed lawfully, fairly and transparently. It doesn't tell you how to do that. It leaves that up to you, which on the one hand is great because you get to adapt that to your business needs, and on the other hand is slightly alien for a lot of organizations that perhaps have never really thought about data protection in terms of governance and accountability and risk management in the past. So it's about protecting people basically from each other. It's about making sure that any interference with the intangible self, with the you that is represented by your information, is done in a way that's proportionate and fair and has respect for your rights and freedoms. So it does that by putting some responsibilities onto organisations that are processing personal data, some duties, some obligations, and it does that also by conferring rights onto individuals. And to keep everybody on the straight and narrow, it also provides for regulation and enforcement. And here in the UK, enforcement is done by our Information Commissioner's Office. So it's basically data protection law rebooted with an upgrade.
Yeah, so a lot of it is based on things that exist already.
Oh yes, most definitely. Yeah, there's very little that's actually really new in GDPR.
Okay, but I suppose with the GDPR, what's happened is it's brought it to everyone's attention in a way that perhaps it wasn't before, and there is quite a lot of terminology around this, which is new for many people. So if we can just go through some of the key components of that.
Yes, absolutely. So it's important to understand the language because otherwise confusion can arise. So personal data is a core phrase in GDPR. It pops up quite a lot. And it basically means data which uniquely identifies a living individual, either on its own, so for example, Rowenna Fielding, Senior Data Protection Lead at Protecture, or together indirectly, together with other data. So if I wrote an email to you saying, I'm the nice lady who was banging on about data protection on your webinar the other day, you would know that that was me, even though my name wasn't actually mentioned. There was no specifically identifying detail in there. And that's really important to bear in mind because it's very different from the American phrase PII, personally identifying information, because PII is only information that is itself identifiable. Personal data is much wider than that. It could be a whole bunch of details which individually could apply to anybody, but when you put them together, they single out a specific person. And it's also important to note that identifying doesn't have to be by name. You just have to be able to single out a living individual and do something in relation to them specifically or affect them specifically in one way. So that's probably the most important definition in the whole of the 173 recitals and 99 articles. Yeah, I do know
thank
that.
Thank you for reducing that so much. That's good. So that's personal data, and then there's what you're doing with that personal data.
Yes. So this is another one that can lead to confusion and problems if it's not understood properly. So processing is pretty much anything and everything that you can do with personal data, whether or not you're doing it on a computer. So sometimes people assume that just because they've got personal data sitting in a box in, say, an archive provider or a storage locker, they're not processing it because they're not actively doing anything with it. But actually, just storing it is processing. So processing covers collecting, generating, acquiring, storing, managing, maintaining, updating, analyzing, transmitting, using, even deleting. Pretty much everything and anything you can do with personal data, it's all processing. So anyone who assumes they can get round GDPR by putting everything on paper and then locking it up is going to find that they're sadly mistaken, I'm afraid.
That's good. I imagine there are lots of people thinking certain things at the moment, and this is why we're doing things like this, is to clarify the position. So I suppose with processing, for the PR industry in particular, especially using Vuelio, it would be things like building media lists or distributing press releases, tracking results like open rates, click-through rates, even permissions for certain media contacts and alerts for like media monitoring. All of this is processing personal data to some extent.
Yes, absolutely. Yeah, those are all things that are processing.
Excellent. So the next definition is data subject.
Yes, so data subject is basically shorthand for the living individual who is the subject of the personal data, which is a bit of a mouthful to have to say quite often. So it's you, it's me, it's everyone on the call, it's everyone out there. if you're a living individual and personal data is being processed about you, then you are a data subject. You are the data subject of that personal data. That's a nice and easy one.
That's a nice and easy one, yeah. So I suppose for comms, it's journalists, bloggers, MPs, special advisors, counsellors, members of the public even, just kind of anyone who is alive and has data about them, that's them, right?
Yes, absolutely, and also the users of the Vuelio product. So when you log in with an account, your account details are your personal data, and you are the data subject of, say, the database audit trail.
Excellent. Excellent. So there's two of these two kind of categories that people who are using the data can be split into: the controller and the processor. If we start with the controller.
Yes. So the controller is an organisation. It's always an organisation, not an individual within an organisation. The only time a data controller is an individual is when that's a sole trader. So this is the organisation that just is making decisions about why they're processing personal data and for what and in what way. And that's pretty much anyone who has employees. They are a data controller for employment data. It's any organisation that does marketing or sales. They're deciding how they do their marketing and sales in relation to personal data. It's HMRC. They make decisions on how they process personal data to collect tax. So it's likely that pretty much everybody by default is a data controller for their own business objectives that require processing personal data. But that's only one half of the picture, because we also have the data processor. And the data processor is again an organization, not an individual. And what a data processor does is that it can only take instructions from the data controller. So, for example, if you were using a platform to send out emails, and that's all the platform was doing, they would be a processor, because they're not allowed to make any decisions about why and how the information, the personal data, is processed. So a data processor can only follow the controller's instructions. As soon as they go outside that, they make themselves a controller. And this is significant in GDPR because pretty much all of the legal responsibility and liability sits with the data controller. The data processor is only really directly liable for information security requirements. So when a controller is using a processor, they need to be very, very clear about what that processor is and isn't allowed to do with that data.
Excellent, which is what comes in the contract.
Yes, that's right, yeah.
Excellent. So in terms of Vuelio, when we are building our database of all our influencers, we are a controller because we're deciding how we do that and what it is for.
Yes, so you are the data controller for the stuff that you put in the database which you make available to your customers, that's right.
Excellent.
And you're also a data controller.
Sorry, go on.
No, that's okay. I was just going to say you're also a data controller for your own HR and marketing.
Yes. And when we give the database to our clients, and our clients are using it, they're deciding what they're doing with that data. So they become controller of the database.
Yes, that's right. So where clients are adding their own contacts into the database and managing the database in ways that meet their business objectives, they are a data controller, and all you're doing is providing a platform for the data to sit on. So you're a processor in that scenario.
Excellent. So we are a controller when we're controlling the database and managing it. When our clients are doing it, we become the processor while they're the controller.
That's right, yes.
Excellent. And also a lot of our clients use stakeholder management, and they also add notes to contacts and stuff. So for that information, they are sole controller and we are sole processor because we have no say over how they're doing that.
Yes, that's right. If you were to take that information and reuse it for your own purposes, then you would have made yourselves a controller. And if you did that without the permission of the original controller, you could find yourself in hot water. But obviously you wouldn't do that.
obviously Vuelio never does that. That's not part of our practices. And that is all contractually written up too. That's excellent. Good. So that's kind of the language that we're using. Now there's a kind of maybe a bit of fun we can have with some myths that have come up about the GDPR. So I'll play the part of the myth creator, and if you could just solve the myths for us. We might need to go through these a bit quickly. I can see there's quite a lot of questions already coming in, and we will definitely get to those for the Q&A. So let's go through the myths quickly, and we'll move on to the Q&A. So the first myth is that GDPR changes how organisations can do email marketing.
Yeah, so actually GDPR says nothing whatsoever about email marketing. The requirements for consent for email marketing to individuals come from PECA, Privacy and Electronic Communications Regulations 2003, and that's been around 15 years, and that always said that for business-to-customer marketing, you have to get explicit prior consent. What GDPR has done is it's raised the standard for proving that you have consent. You've actually got to have good evidence, which is why a lot of organisations are now trying to obtain that evidence or upgrade that evidence by sending out emails saying, we have to get your consent. Actually, they always had to get consent. It's just perhaps now with GDPR, they've only just realised it.
Right, so people who are now thinking they need consent if they didn't before may actually be breaking the rules.
They probably were for about 15 years. It's just only now that those rules have really become significant in public consciousness, yeah.
Excellent. I'm sure that's made quite a few people nervous, but let's move on to the next myth. So data protection is mostly about data security.
Yes, so up till recently, when you said data protection, most people thought about things like passwords and locking up bits of paper, and those things are very important, but there are 7 data protection principles in GDPR, and only one of them is you must keep personal data secure. Fairness and lawfulness, transparency, proving that you're doing things right, keeping data accurate, upholding people's rights. Those are every bit as critical as security. So if you just focus on security, you're going to have just as much risk of getting into trouble as if you don't focus on security.
Excellent. GDPR requires consent for personal data processing.
So this is the one that always gets the response, the standard data protection person's response of, it depends. Consent is one option, but it is not necessarily the best option. It's not even necessarily the appropriate option. There are 6 options, and for example, they are when there's a law that says you have to do the processing, like keeping health and safety accident records or tax records, when the processing is required for a contract, so a lot of HR stuff will fall under that. When somebody's about to die right in front of you, if you don't process their personal data, it's okay to go ahead and do that. Where you have a legitimate interest in doing it, where you are a public authority or doing a public task, and where you have consent. But unless consent can be informed, freely given, specific and unambiguous, it doesn't actually meet the test for valid consent. So the question to ask is not, do I need consent, but what's the appropriate basis for processing? Always start there. Go through the others first, and then see what you're left up with.
Excellent. And within Vuelio, obviously, we've been talking about this a lot, and our basis for processing is legitimate interest. And I think we will talk about that a bit more as we go through these myths, but that is our process rather than consent.
Yes, that's right, yeah.
Myth, we must delete everyone who hasn't consented to be on our database.
Yes, so this one is another one of those, it depends. If you decided that you were only going to put people on your database if they've given you permission, then anyone who hadn't given permission, you would need to delete. But it's very, very rare for consent for holding data to be the appropriate option. You have to let everybody who's on your database know that they're on your database, because transparency is an explicit requirement of GDPR. It's in the first principle. But you don't necessarily have to delete them if they haven't given consent. If, for example, you have to have that database in order to deliver a contract with that person, if you have to have that database in order to follow a law, if you have to have that database to be a public authority doing public authority things, or if, like Vuelio and probably a lot of your customers, you have decided that you have a legitimate interest in keeping this information, and you've done an assessment and a balancing test to make sure it doesn't undermine individuals' rights and freedoms. So the answer, no, you don't necessarily have to delete anyone who hasn't consented, but you do need to think about what the lawful basis for processing is, and you need to let people know that you've got their info.
Excellent. And I know obviously a lot of our clients will already know this, but we have a human research team who spend a lot of time speaking to the influencers that are on the database to let them know what we're gathering about them and why we've got that information, and actually working with them to make sure their profiles are to their preferences. So we do that in-house, and that's our, as being as transparent as possible, because obviously it's not all just about security.
Yes, absolutely. No, that's a really good approach.
Excellent. Myth: suppliers are data processors because they're being paid to do stuff.
Yes, so it's not about the money flow, it's about the data flow. If a supplier is making their own decisions about why personal data is being processed and how, then they're going to be data controllers, even though somebody else is paying them to make that decision. So, for example, if I'm a market research company and I have a special proprietary algorithm for sorting people into segmented groups, and then I make the results of those sorts available to my customers for a fee, then I'm still making decisions about how it works and who goes where. So I'm still a data controller. So just because money is going to a supplier doesn't mean that the person paying them is calling the shots about the data. It's really important with supplier relationships to look at the actual facts of who's making the decisions.
Okay, so it's not, you shouldn't make assumptions based on money. It's really understanding what's going on, which is the case for the rest of the GDPR.
Yes, pretty much, yeah.
Myth: individuals own their personal data, or organizations own personal data.
Yeah, so according to GDPR, that's certainly not the case, because there is no mention of ownership anywhere in this law. This law is not a property law. It's not about kind of rights of ownership. It's about rights and freedoms of individuals and obligations of organizations. So talking about ownership is kind of a red herring, because data just exists. You can't own it. If I give you my name, you don't then own my name. But then I can't really own my name either. So forget about ownership. It's just not a thing in terms of GDPR. Think about principles and duties and obligations and individuals' rights.
Excellent. Next myth: anyone non-compliant on the 25th of May faces huge fines.
So actually the Information Commissioner herself, Elizabeth Denham, has had to put out a ICO myth-busting blog series, and one of the first things they tackled was scaremongering about huge fines. The ICO has never ever levied a maximum penalty. They can go up to $500,000 at the moment under DPA and PECA, and they never have. And they have said very clearly that their approach is going to be education and engagement, and enforcement is pretty much a last resort, reserved for organizations that are either obviously not making any effort at all, or being reckless, or are deliberately breaking the law. So it's not as though the ICO is going to be sending out SWAT teams at 9 o'clock on the 25th of May. That's just not going to happen. No one will actually be compliant on the 25th of May, because data protection maturity is always going to be a journey, a work in progress. But what you do need to do is show that you have plans, real plans with actions and dates, not just nice aspirational ideas. You have to be able to show evidence that you're making progress and you're thinking about this stuff. And as long as you can do that, even if you're not absolutely perfect, welcome to the rest of the UK, then you won't necessarily get into trouble. But if you're making decisions that are, well, we know this is illegal, but we're going to do it anyway because it makes us money, then you are obviously in a much more precarious position.
Yes, excellent. So, and I imagine joining sessions like this and reading about it and learning about it and education internally is a big part of showing that you are doing what you can.
Yes, that's definitely a good start. Obviously, all that knowledge and that learning does then need to be applied in looking at the business as usual process and change management process and thinking, well, how do we bake GDPR into this rather than bolt it on?
Excellent. And I know many of our clients that will be listening in would have received, we've sent out a number of white papers on the subject. We've also actually got a very specific module for the GDPR, which is going to be released soon, which will help people, especially keep the audit trail, but manage and maintain their GDPR compliance around subject access requests and things like that, which is very exciting. So we've done myths, now some mysteries. How do we tell people we have their data and why we're using it?
There's no right or wrong answer to that. The requirement is that people are informed. Now that doesn't mean you have to go rushing up to every single person individually in person, grab them by the lapels and give them a lecture on how they're using their data. It could be that you put something on your website, you add text to your forms or your communications materials. As long as the outcome is that they understand what you're doing with their data and why, then however you do it, you can get creative. So EasyJet recently released a video privacy notice for their customers. Also important to note that you don't have to put everything in one place, in one huge long document. Really the best privacy info is given on a just-in-time basis and is quite bite-sized, very clear, very accessible, and not written in lawyer speak. So that one's kind of up to you, and you get to be creative. And obviously, as communications professionals, you know how to reach people, to engage people, and to make your messages clear and understandable. So harness that when it comes to privacy info.
Excellent. I think we've just reached the half an hour point. We've still got everyone on the line though, so if everyone's happy we'll carry on so we can get through hopefully what will answer some questions, but then we will answer people's questions coming in. So how do I know if something is fair, reasonable or appropriate?
Well, that's kind of in the eye of the beholder. It's up to you. If you can make a justification for what you're doing being fair, reasonable or appropriate, and you write that down, then you have at least fulfilled the accountability requirement. If you're not sure whether or not what you're going to do with somebody's data is fair or is reasonable, the best way to find out is to get a group of the target demographic together and ask them, explain what you're planning to do and say, do you think this is fair? And if they say yes, then you've got great evidence to support your decision. And if they say no, then maybe it's time for a rethink. But as long as you can justify what you're doing and you're prepared to justify what you're doing in public, whether to people on social media or in a TV interview or in a public statement, then you can do whatever you can stand by. You do have to be transparent about it.
Excellent. This forms part of the balance test that you'd have in place for legitimate interest, for example.
Yes. So being fair is always part of GDPR, no matter what basis you're using, but reasonable and appropriate is very significant when it comes to thinking, can I actually use legitimate interest for this processing? Yeah.
Excellent. And I know we've been asked by a number of our clients, so Vuelio's approach to fair and reasonable for the legitimate interest is that we believe that all our influencers, and that's everyone from the journalists, the editors, the bloggers, the MPs, the councillors, we believe they would reasonably expect their details to be used by comms professional for the purpose of building mutually beneficial relationships and sending targeted comms content. And obviously we provide a clear means to opt out as well, so that part is a fair and reasonable expectation for them to have their data processed.
Sure.
Excellent. This is quite a big one. How do I become compliant with GDPR?
Well, the facile answer is become compliant with GDPR. But I think really, rather than thinking about compliance as in sort of tick box, one point in time, audit, snapshot, job done approach, think how do I embed the principles into business as usual? How do I make sure I'm meeting the obligations? How do I make sure and evidence I'm upholding people's rights and make sure that that's really woven into managing change, organisational culture, and that you've got good records of everything. If you've got 20 years worth of compliance debt for data protection, then obviously that's going to be a pretty big job. But as I said earlier, you don't have to have got everything done by the 25th of May. You do at least have to have a plan. And obviously I would say this, but if you need to hire outside expertise to advise you on what the law says and how to apply it, then that's definitely a good thing to do if you don't have in-house expertise.
Excellent. And
but it's not going to be an overnight thing. We did have some guidance notes in the rest of the presentation, but I'm going to jump to a lovely picture of you so that we can do some questions from our audience, just because there are quite a lot coming in. We're not going to have time to answer all of these, but we will follow this session up with a blog post where we will answer every question that's been asked, and also the slides and the audio recording will be sent out to everyone afterwards so they can review it at their leisure. So I'm going to start with a question here that says, I assume that GDPR applies to postal communications in the same way as it does to digital comms. Right, so GDPR applies to personal data full stop. The law that addresses what you can and can't do with marketing, specifically electronic marketing, is PECA. The GDPR doesn't say anything about postal versus email. That all comes from PECA. So you need to look at both of the requirements of both laws and at your comms strategy and work out which bits apply where. So PECA will apply to any electronic marketing, and the rule of thumb is for business to customer, you'll always need explicit prior consent. There are a few exceptions to that, but you'd need to start getting into that in regards to your particular business processes. But GDPR doesn't talk about how you do marketing in any way.
No, it's just the data that goes behind the marketing.
Yes.
Excellent. Someone said, I think this is in relation to personal identifiers and identifying personal information. Does this mean that email addresses like hello at or info at or sales at can still be used?
So yes. So if we're talking again about PECA rather than GDPR, you can send business-to-business marketing without needing consent. And so that might mean reception at or sales at or whatever. But it might also mean that you can send the marketing to a specific role title or person, because if it's the content of the message is business-to-business, then you don't need consent. But again, that's PECA rather than GDPR. GDPR is much more about data management and organizational culture than how you do your marketing.
Okay, excellent. So this is a question, I guess, about like how often you have to refresh data. So someone said, I have a number of journalist contacts who I liaise with directly. Most of it is a two-way conversation. If I don't speak to them for a few weeks or months, how does GDPR work? I presume I'd be clear because we've had previous conversations. So is there like a limit to how often you have to tell people that you've got their data, or do you have to refresh it?
No, that all you need to do is make sure they understand what's going on and why. Now, if in those few weeks you were going to make some drastic changes to how or why you were processing their data, then that would be a trigger for updating privacy information for them. But if the status quo is working, then yeah, there's no reason to just go back and keep telling them the same thing. That's not needed at all. So like I said, the outcome is that they understand, they have current and up-to-date information about what you're doing with their data and why.
Do contact lists in Outlook count, and those that are in spreadsheets or documents?
So if they contain information, data which could be used to identify a living individual either directly or indirectly, then yes. So it's very likely that those sorts of lists will be or will contain personal data, which means that they've got to be processed fairly lawfully and transparently for specified purposes only. They've got to be as accurate and up-to-date as is needed for the business purpose you've got them for. You can't keep them for longer than the business purpose you collected them for. You've got to keep them secure, and you've got to be able to demonstrate all of those things.
And I suppose if you've got lots of
spreadsheets, in a nutshell.
If you've got lots of spreadsheets lying around on multiple computers in multiple places, then being able to keep them secure is probably a concern.
Yes, yeah. So data management is it's not an explicit requirement of GDPR in itself, but you pretty much can't meet the principles unless you've got good data management processes and systems and culture.
Excellent. And yeah, well, we've been recommending to our clients that do as much as possible within Vuelio rather than taking it out on spreadsheets, so that it all stays in one secure place that we know is secure and they know is secure.
Very sensible.
Excellent. For companies who have years' worth of photos or captions and potentially quotes included on their public-facing newsrooms, are we expected to go back and delete images or remove them? Where do we
that one's going to be
the original permission?
That's a question to which the answer is going to be the standard data section. It depends, and that's not a cop-out. It's because it really does depend on the purposes that information is being processed for, both when it was collected and now. It depends how it was acquired. It depends what you're planning, whether or not you're planning to continue to use that information. If it was acquired for and used for journalism, then there's a big exemption from a lot of the data protection requirements. Ditto for historical archiving. So I would say with that one, first thing to do is establish the purposes of processing, why you've got these images and what you're using them for, and then go through the principles.
Okay, excellent. I do have another question about pictures, but I think we've probably covered most of that. What happens if we are a micro business and control and process info ourselves?
So if you're a micro business, the rules are pretty much the same for a macro business, although you don't necessarily have to keep the records of processing activity requirement in Article 35. I would recommend that you do anyway because it's a piece of critical business intelligence. But if you're not acting as a processor for anyone else, then you don't need to worry about that bit. All you need to do is look at the data for which you are a data controller and, like I said before, apply the principles, understand the rights, sort out data management culture and systems. It's a very, very big, wide field, and I recognize that the answers are not giving you step-by-step instructions, but the thing is GDPR doesn't require any kind of step-by-step process to be followed. It defines the outcomes you need to achieve and says how you get there is up to you. Do whatever works, but end up in this sustainable position.
Okay, we had quite a lot of questions coming in asking about reaching out to people. So I think we've probably covered this in the thing, but I'll ask one anyway, just so we can clarify. Someone said, if we have a media list today of 300 journalists on a spreadsheet, do we need to contact each to say we're holding the journalist's names, publication, and emails in this way?
So the first question I'd ask in response to that is, do they know that you've got their data? And if the answer is yes, then you don't need to tell them again. If they don't necessarily know, or they don't remember, then the next question would be, where did you get their data from? And if it's data that they've published on their website, say with a note saying, please contact me about stories I might be interested in, or something like that, then I think it's reasonable to assume that they know that people have their data for that purpose. But if you've got that data through third-party data brokers, or you've created fake Facebook accounts to harvest it, or something equally slightly suspect, then it would probably be a good idea to let them know. But that doesn't mean that you can't spin it into here's a great way to build our relationship. What would you like to hear about from us, type communication.
Yeah, so it's an opportunity rather than a chore.
Definitely, and it's a competitive advantage as well. Privacy is definitely becoming more significant in the eyes of public and industry, and if you can demonstrate that you are both respecting personal data yourselves and not going to drop anyone else in it, then you're in a good position market-wise. Perfect.
Okay, I think we've probably got time for maybe one more. I'm getting the thumbs up next to me. So this is something I'm not sure we've covered, but I think I'm going to know the answer. If we tell people we hold their information in our database and they request it to be removed, however, we have a legitimate reason for keeping and using, do we have to remove all their information?
So the short answer to that is it depends.
Yeah.
Sorry about that. It always is. So there is a right to erasure and a right to object to processing, but they're not absolute rights. So if you can demonstrate that your legitimate interest in keeping the information is so strong as to override that person's preference, say for example you need to keep it for internal auditing purposes or contract potential defense of contract liability, or you have a good business intelligence process that you want to keep the data for, then you can make a case back to the requester saying, well actually we really want to keep it because of this, and this is how we're going to safeguard your rights and freedoms and make sure it's not reused for anything else. At that point, the person has a choice. They can either go, oh yeah, all right then, I'll leave you alone, or they can go to the ICO, who will look to see whether or not you've made a case for keeping that information, and if that case is convincing, or they can just go on social media and say horrid things about you.
Yes, which people often do.
Yes,
not me
but you really
personally,
can't do anything
I just want
about
to clarify. Wonderful. That's all the time we've got for the live Q&A. Everyone that has asked a question will get an answer to their question. We will sort that out. A number of our clients have asked specific questions. I just wanted to highlight we do have a guide to the GDPR video and the GDPR on our website at www.vuelio.com/UK/GDPR. It is a formless download, so you can download that without submitting your information. Thank you very much, everyone, for listening. And Rowenna, thank you so much today for your time. It's been wonderful and hopefully very eye-opening for everyone.
You're very welcome. Happy data protecting, everybody.
Happy data protecting, everybody. Thank you for now. Goodbye.
Thanks.